That the single bench directed the CBI in order to secure appointments of undeserving candidates in Group D post was not found favor of the honorable judges of the division bench in High Court. On December 6, the Justice so disposed of all the appeals by taking the decision to conduct an inquiry to reveal the truth in connection with illegal and irregular appointments made in Group D post by constituting special team to be monitored by a retired judge of the High Court. The honorable judges of the division bench modified the direction given by the judge to secure equal opportunity to successful and deserving candidates for appointment in Group D post by revealing the truth and by fixing up the responsibility for the misdeeds of giving a recommendation and appointment in Group D post in an illegal manner. Since the inquiry committee could not submit the report, the completion of the inquiry within time, these are procedural aspects. I am not telling my lords. Then kindly turn to
page 40.
Paragraph page
Page 470.
paragraph paragraph 6.1.
Page 475. 471 চলে আসো 474.
Paragraph 6.7 of the three. of the illegal procedure adopted by the Central Commission of the Regional Commission findings of Justice Bar. Scanned signatures of the chairperson of the Regional Commission by keeping them in the dark after the the panel on May 4, 2019. The said 609 successful candidates who obtained false recommendations from the Commission also received appointment letters based on the false recommendation from the new building of the Central Commission situated at Anandalok Hospital. We have annexed the names of 609 made analysis of the information collected from the Central Commission the board and found that names of 318 letter issued by the board. Who got false recommendation appointment was even names did not appear either. Kindly come to fixing of responsibility. Page 483. Result of illegal procedure. by the Central Commission. Now coming down to the page 483. This is a illustrative. Nobody can, even the School Service Commission. After expiry of the panel, though those candidates did not qualify for being considered. But these are all, SSC is illustrative. Nobody can, even the School Service Commission, it is last date of hearing, come up and identify that these are the figures to stick by. A place before Lordship, they said identified so far. There are other areas manipulation also being deliberately for in violation of statutory provisions. And appointments even in excess of vacancies. All these things are there. Ultimately, when the CBI conducted it, they have all these things are there. Ultimately, and the entire argument before the High Court was that you cannot look into those machines. None has argued, with the best of respect and stand to be corrected, that we are genuinely candidate. We have nothing to do with this. Please segregate us. I don't find from the entire judgment, which was so elaborately written by the Honorable Judge, making all pain. Therefore, there was no scope for into those machines. None has argued, with the best of respect and stand to be corrected, that we are genuinely candidate. We have nothing to do with this. Please segregate us. The tiny turn to page 1264, volume 5B.
Only audio there, कौन?
Yes.
Now page 1262. Judge, taking all. What you will kindly note, two important state organizations, like Saraswati Press and Shilpo government organization. They were initially knocked out. And one ground that they have only given quotation for 1 and 2. And the rest are, you can see the rate quoted. So for the AAPC is concerned, only difference 9,000, 8,500, 8,000. All 500 important state organizations. And this was like Saraswati Press and Shilp government organization. On what ground? That they have only given the quotation for 1 and 2. And the
They have given
consolidated transporting cost transfer. Therefore, basic work was designing and printing and scanning with preparation of results. kindly come to the next page.
যেরকম পারবি সেরকম কর, আমি ঘরে এখন আইস বাবা
Page 1 to 6 4.
পিনটাকে ফোন করে পিনটা আসবে,
From the
ওদের এখন আধা ঘন্টা
Vice
দেরি হবে।
President of NISA.
সেটা সে
Date
এর
is
ধরে পিন্টুর
1st of
ধরে
December
পিন্টু যে মারুতি
2016.
তার ধরে জেনারেটার পড়েছে, সেটা লোড করে নিয়ে
Quoted. So scanning of AMR and processing of result, both secondary
তৈরি হবে
higher
বলো।
secondary examination.
ফোন করছে
What quarter being issued?
ঘন হয়েছে লাটিন
Dated 24th of October 2016. With reference to above, you are requested to start scanning of AMR sheets of both secondary higher secondary and process result of the same review process. This is at the very same office on the very same date by Ajoy Shah, Sam Shah, who is representative of NISA. How could he be there on the date when this notice was issued?
ওটা অন্যরকম করে লাইভ ছাড়ি দিয়েছে, ছবিটা দিয়ে অডিওটা দিয়ে দিই যাবো তাতে,
And this was
তাতে বেশি লোক
handed
দেখবে, ঠিক
over
আছে?
on the very same day when this was opened. This is 29th of March 2017. Subject of scanning of AMR and processing of result in connection with third RLST. What are the what assigned? Scanning and processing of results, refund of AMR sheet after completion of the process, handing over of scanned immediate AMR record of results, and other information soft copy mode with the clarification. Therefore, these AMR copies, scanning and printing AMR, scanning and printing down, and then 1267, 7 September 2017. Some additional work is assigned to them without having invited them to participate in anything in the process. And then again on 7th of September, the Honor Shah was in office and received this. And the nature of job awarded was understand for finalization of typing schedule. The work includes arrangement of venue, conduct of type test, evaluation of paper, handing over result. But all these things taken in a basket. Next page. This is 29th of March 2017. Subject of scanning of AMR and processing of result in connection with third RLST. What are the work assigned? Scanning and processing of results, refund of AMR sheet after completion of the process, handing over of scanned images of AMR record of results, the other information soft copy mode with the clarification. Therefore, these AMR copies, scanned images were handed over. Down. And then 1267. 7 September 2017. Some additional work is assigned to them without having invited them to participate in any tender process. And that again on 7th of September, the Honor Shah was in office and he receives this. And the nature of job awarded was in understand for finalization of typing schedule. The work includes arrangement of venue, conduct of type test, evaluation of paper, handing over result. Therefore, all these things taken in a basket, it would be apparent without any out of doubt that this was done with now.
List of persons appointed after election vacancy and then recommendation.
Now kindly take the trouble to turn to paragraph 271 of the judgment. This is very important. At page 228. Rather, I would be prompted and tempted to read from paragraph 262.
Page number?
Page 227, 219 of the input judgment. Paragraph 269. SSC board and state government have consistently stonewalled any queries with regard to the selection process. Conduct of three authorities during the course of hearing can be classified as anything other than being cooperative. The Secretary of SSC has submitted a statistical report with regard to illegalities in the appointment in the respect to the four categories by a signed report dated March 6, 2024, to which we have recommendations made by SSC in respect to the four categories and number of appointment letters issued by the board in respect to the four categories. Significantly, SSC had recommended 11,425 candidates for appointment. Post of assistant teachers for 9, 10, whereas board $1,539 excess appointment letters. Now, who is going to identify them? Then the board has entitled to similarly in respect to assistant teachers for class 11 and 12. Nine excess appointment letters than entitled to. See, board has generated so and so, thereby generating 460 excess appointment. SSC has contradicted such justification of board by claiming that no such recommendation letters were issued. Board has no authority to issue appointment letters unless such can far in excess of the recommendations. There have been manipulations, illegalities in the recommendation also. SSC at no stage of hearing claimed or on order of court. SSC proceeded to withdraw cancel recommendations in favor of candidates participating in the four categories. On the basis that there were manipulations in obtaining recommendation. SSC had accepted the data Pankaj Bansal by CBI. Then kindly turn to paragraph 288.
Two
288. None of the Article 12
Yes.
None of the Article 12 authorities had ever disputed the genuineness, veracity, authenticity, and legality of the data contained in hard disk seized by CBI from Mr. Pankaj Bansal at any material point of time. SSC had accepted such data acted upon hard disk seized by CBI had been produced in court, CBI had granted inspection of documents downloaded from such hard disk to persons seeking such inspection pursuant to orders of this bench. None of the persons taking inspection have contended that the OMR sheets are not theirs. The OMR sheet bear unique barcode, and I have already spoken about this. Therefore, this is the wholesome figure of an illegalities committed. And I don't have to do that.
But their contention is OMR sheets under the rules have to be only maintained for an year.
But the decision was they will destroy it, keeping mirage copy. That is the decision of the SSC. That affidavit I have placed with Gatwalkota.
So the mirror copy was there, but there is discrepancy in the mirror copy.
The mirror copy was not there.
They,
Mirror copy was also not kept. That is the whole.
yes, to do it, they kept it on their server or their computer rather than the
SSC storage, it was not there at their own admission. Volume 5, it was the decision. I just read out once again loud. Chairman of the Commission, in his executive capacity after the expiry of 1 year in absence of rules, issued executive instructions by letter dated 22nd July 19, directing that the answer scripts, OMRs and other papers related to the disposal and destroyed as the period of preservation of the same had already expired. The same was to be destroyed after scanning in digital form and creating mirror image. That's the norm. The physical image is destroyed to get rid of the space. But there is no lack of space in space.
2023 records.
40, 23, 35.
And this was the affidavit filed before the Supreme Court by affidavit on
এরপরের দিন না তোমার সব সাহস পর সেটিকে হইতে সেটি কিন্তু আগে একটু মোবাইলটা একটু আটকেছিল
সেটি আটকায়নি না
23.
টেন্ডারেও বলছে ওদেরকে প্রিজার্ভ করতে।
I really would like to bring one judgment to your Lordship's notice, where the Supreme Court has said if there's any out of doubt, then the entire thing should be cancelled. Court directed to do it afresh. What's the harm in it?
for fresh means everybody has to study again. So,
They are all
that's exercise.
some trouble has.
Outside.
Not outside that. Well, it will be pushed back to 2016 situation. Who are the candidates? They will appear, and the age bar will become known. Well,
No, but if that examination is being held today, there's no question of age bars.
that's not. Even if somebody has expressed their doubt in mind that age bar would come in, it will not come in. Now that I
Not meant, it will not be a fresh advertisement.
no, to the participants who had participated. Now that I was not tempted to not cite this judgment, Tanvi Sarwal, where I'm reading from paragraph 20, as would be available from the status report.
Yes.
As would be available from the status report, out of 123 solved answers of particular code and retrieved from the mobile set of one of the persons arrested. Answers, 102 answers were found correct in a comparison with the answer key provided by CHAKRI. As referred to here, above 358 mobile numbers had been pressed into having regard to the uncompromising essentiality of a blemishless process of examination involving public participation, we have no alternative but to hold that the examination involved suffers from an infraction of its expected. We are conscious of the fact that every examination being to suffer from some shortcomings. But and the nature, as exhibited in the present case, demonstrate a deep-seated and pervasive impact, which ought not to be disregarded or glossed over. It may amount to travesty of a proclaimed mechanism to impartially if such an examination is saved, merit would be causality generating a sense of
Just 1 minute.
when the allotment of academic marks, give benefit to the persons who have paid money, the alteration of their personal education.
So OMR sheets. Is the no, scanned copies two are available. There's several or two.
Scan copies available. They supplied, they now say this is from the CBI report. That's the explanation given for the court.
No. That's a fiction. There are two OMR scanned copies. Both of them can be compared to know whether there's any violation.
So there is no two copy.
হ্যালো, যাবো একটা, আমি কাজ করছি।
Only one copy which was seized by the CBI, nothing else.
No, there are two copies available. There's only one. No, Margaret Bansal and the other person also had.
Oh, Pankaj, yes, but the same. The same.
No, there are two. I thought.
Where is the other one?
Data scan tag.
Data.
Examined them and have segregated.
No, there are two sets available. Are the two sets matching or not matching? The two sets as per them were matching.
That's much it.
On the authenticity of that itself, because the marks which have been allotted sheets, but they were marks to be allotted on account of academics.
Qualification, then OMR.
Please allow us.
Academic rules of Lordships is the academic marks, is the OMR sheet, and finally, the Lordships, the verification. So when all these three are added, the percentage which is given to my academic record, your Lordships, I'll just read the rule, is about 40%. Your Lordships, even if I do badly in my OMR, I would still have higher marks. I'll come to all that, your Lordships. I'll show to your Lordships that aspect.
No, no.
958, that is 958.
May I now that Lordship now kindly takes up the rules. And confused. Commission shall arrange written examinations. The commission shall determine the method of written examination, contents of paper, so and so. Then after the evaluation of OMR sheets of the written examination, the central prepare call for personality test category wise on the
Okay,
basis.
now, no. On the basis of the scanning done, after evaluation, shall prepare and publish on the website the details of candidates who have been called for personality. Now, therefore, the sheet were already declared then.
No, your Lordship, they were not clear, but that was one of the orders that
Is
the
it?
High Court made, and consistently they did not.
This was not done.
Not done. triggered the litigations.
This was not done.
No. Only after the Honorable High Court intervened, directed, then some marks were disclosed.
In the year 2000.
No, this was not done. This was not followed.
No, Your Lordship.
In the year 2022.
That's why the direction was given.
I'm asking him.
Relevant rule.
Before the interview or after the interview?
Before the interview. Before the interview.
No, no, publication was done.
When it was challenged before the High Court, then on direction of the High Court, it was done after everything was.
In 22.
It was done in 2022.
June 2022.
Now kindly come to know the relevant definition of interview list.
Petition, was it disposed of within a year or after the year?
Petition. The petition was still pending, many issues.
You read out. Direction was given by the High Court. Result, OMR result. When was that petition filed?
In 2021,
And when was the result declared?
2022.
22,
June 2022.
22. Put about it.
How can that? Sheet were declared. Correct? You just now said that.
Probably I'm not able to communicate. But OMR sheets were never disclosed. Marks were
Correct. You said the marks obtained in the OMR sheet contrary to clause number 6 were declared pursuant to direction given under writ petition after the final results had been declared. Correct? I asked you when was that writ petition filed? You said 2021. When were the results declared? You said 2022.
dates are confusing.
Results declared in 2018.
But the
Results were declared in 2018.
2018,
When was the writ petition filed?
2021. 2021 it was filed, that's why 2018. When we come to know, then we challenge. Now that
No.
now it was filed seeking the details of that, the merit standing, what marks were to obtain as per the rules. That was the writ petition. Now kindly turn to definition clause 2E. Interview list means a list of candidates to be called for Rule 2, Sub-Rule E, page 1998.
Very confused election.
Yes.
Interview list means a list of candidates to be called for personality test, category wise on the basis of merit, that is marks of written test, academic and professional qualifications. Therefore, the academic marks and professional qualification is also very important for calling for interview. Then panel, I am not troubling my lot with the panel. So kindly come to rule 12.
Page number?
The page is 2001.
Yes.
selection of candidates and preparation of panel. The Central Commission shall arrange for proper custody of all online applications which may be received by its against the vacancies. The Central Commission, after receiving, I'm not troubled with that. Then 4, the Central Commission shall determine the method of written examination, contents of papers, duration of examination, time and venue of examination, and other matters. Here, the Central Commission delegated everything to NISA. Statutory obligation was the Central Commission should do it, they did not do it.
Yes, but this may not be violated. This may not be really violated. This is only the method they have to determine. This may not be violated.
Yes, well, I'm just making my submission also consider this. Then after the evaluation of OMR sheet or answer sheet of the written examination, the Central Commission shall prepare and publish in their website with all details of the candidates to be called for personality test, category wise on the basis of merit in the ratio of 1:1.4. This was not done, and violation of this ultimately triggered the petitions.
2008. What published?
When was this petition filed?
2008.
This petition was filed in 2021.
Not in 18.
No, they didn't know this.
You didn't know it because the merit list was never published.
They were published.
So there were letters which were sent.
But when we find that somebody got appointment, we wanted to inquire, how could he get appointment? Because I know him better than that. I was never worse than him. Then ultimately these petitions came and kindly come to page 2008.
So complete. They were published.
What was published, I'm sure your lordship. Kindly turn to 2008.
Yes.
Here lordship will not find what are the merit position, what are the marks obtained, nothing, all vague.
The wait listed was published.
Wait listed, merit list, everything without giving the details of it. As per the rules.
When was this published?
This was published in 2018.
No, but the merit list was not published. The wait
No.
list was published.
This is not the merit list.
So this W1 means what?
Waiting list 1.
So what? No, the ones who had been appointed, their list was never published.
Okay.
No, was the list of the candidates who were selected published?
Yes, it was published 2018.
Where is that? Where is that?
Without giving the
Which
detailed
page?
marks.
Which
Well,
page?
actually, that is Anil Karachi.
Not been annexed, not in.
No, this is not a part of the Then again,
Where is that list of the students or the candidates who were selected published? When was that published and where is that list?
that list commission can disclose, but we don't have copy.
You don't have copy.
हमारे बोलते हैं हमारा जो है सुनो ना ठीक हो तो
So
কথা শুনে
20th
instruction
of August
No, but that-
2018, a list of selected candidates was
কথা বলতে না
August 2018.
August 2018.
Pilot preliminary result was 10th of September 2000.
And appointments were made thereafter.
Yes.
Now the page 2020, there is a list. This was published pursuant to order of the court. So it says compliance of the order of WPS so and so of class 9 and 10.
Here the marks were disclosed.
This is for the first time marks are disclosed after the order of the court. And this was disclosed in 2022. ও চারজন যদি চারভাবে কথা বলো না মামলা করে যায়
Okay.
নিজেরা কনফিউজ করছে আমার
This is following 5B.
Finally come to the again the rules. That is very important. So we got
2001.
Without marks.
without detailed marks. Without detailing marks, we have published, marks was published after the court order. Now kindly Rule 12, Sub-Rule 6.
You have read that?
No, I'm not Sub-Rule 6 because I did not read.
Rule 12. Sub-rule 6 you read.
Yes.
With all detail.
Therefore, because the requirement was to publish with all details of the candidates. This having not been done, then these petitions were ultimately coming to court for seeking disclosure.
If you read
17, 18 publication, they're not showing that.
2000, if you look at sub-rule A, it says Central Commission shall prepare and publish their website a merit list based on panel of candidates, category-wise of the merits list equal to the number of vacancies and region-wise list on the basis of
This is final list. After
prepare and publish on the website category-wise list, waiting list on the page. It doesn't talk about Six does, and that list is to be published before the academic or professional qualifications of.
This is a merit panel.
After final. Instead of
it is after interview and all details were the requirement of law. Anyway, because that chapter is over, it was published after order of the court and then this.
This list which was published as per this 12-6, none of you are showing us. This 12-6 merit publication according to Mr.
It was not published. It was not.
Which page is it?
No. What was published was the merit list after the
Yes.
after academic evaluation.
Where is it? Which page is it?
No, that's not the point. Let's be very clear. Merit list was not published. The list in terms of clause 6, sub-rule 6 was not published, giving the details of marks of each and every student. No, that did not happen. No, read rule 6 is very clear. No. 12-6 is very clear. Evaluation of OMR sheets or answer sheets in the written examination. After evaluation of the OMR sheets or answer sheets in the written examination, the Central Commission will prepare and publish in their website all details of candidates to be called for personality test, interview list, categorized on the basis of merit, marks, academic, so and so, so and so, in the ratio of 1:1.4. No, with
So Joydeep Gupta, why don't you show us what you published?
Yes.
Which page is the publication that you came out with in terms of Rule 12.6?
please, you must have taken a down print out of that. Which page is it? Or is there none? What you are saying is you could go and look at your marks individually. That's not what. Is that?
Had it been so, there was no question of litigation before the court.
First order would have been.
Yes.
We are asking you which page is that list. Can we have that? Okay.
Therefore, the court not being satisfied that the state government's involvement was very questionable, directed that CBI should also inquire into the matter. What prompted the state to create so much supernumerary post has a different meaning. I'm not going to argue on this. They wanted to diffuse the grievances of the people who are standing at the road. We give you appointment. And an application before the court that we are giving appointment to secure that the persons who have been given illegal appointment, specifically mentioned, do not lose their job. Why? State government were here before constitutional article 14 was stares at our face. Transparency and non-arbitrary is fundamental principle of our jurisprudence. In that background, where I do not take much of your time, my submissions I conclude saying that the entire selection process being vitiated.
Okay.
There is
Next, please.
investigation and let it done afresh. Deeply obliged.
You want to go?
Only about 3-4
Now, just now tell us in brief why the entire selection process is vitiated. It's impossible to segregate and find out the ones candidates who are meritorious with those who are not meritorious. Please come on.
Milord, the High Court, Milord, has given reasons, Milord, why it cannot be
So
segregated.
please do it in your own words. High Court reasons we know.
I can only read those paragraphs, Milord, of the High Court. Your Lordship may kindly see, Milord.
Page 59. Volume edit this.
Page 59. Yes.
Counseling. Class level 11, 12.
Yes.
Again, no marks in this.
No marks.
No marks.
No, there are no marks.
This is for first stage counseling means that is where the academic results will be examined.
No marks is given.
No, marks are not. You are right. Marks are not given.
But the marks are all on the website, right? So each part, if anybody wants to investigate that,
It is given. Always show
But the
there.
marks are not there. The requirement of the rule, Milord, is publication. Milord.
Not just the name.
Page number 82, 1 to 1. That no marks are given. 1 to 1. Page 1 to 1. Page 82. No mark. 1 candidate, particular candidate. Communication, my lord, page 82, my lord. Volume 5, bill. Marks, my lord, are conspicuously absent. No marks. No marks. So where are the marks? Where are the marks?
Marks are not there. Their contention is marks are not required under the rule, sub rule 6.
But if your lordship may kindly see, my lord, that, my lord, it was an ongoing process, my lord, of, my lord, illegalities being detected, my lord. If your lordship may kindly see a paragraph, my lord, paragraph 242, my lord, of the impugned judgment, my lord. This is the stand of the SSC, my lord. So, my lord, it was, my lord, time and again brought to the notice by way of affidavits, my lord. The first line itself, my lord. In course of hearing, SSC did not discount.
Paragraph or
Paragraph
page number?
242.
Paragraph 242.
Paragraph 242, my lord.
213. Yes.
But in course of hearing, my lord, the SSC did not discount the fact that possibilities of further illegalities exist. So they are not certain even, my lord, on the date of passing of the order, my lord, as to the number of illegalities, my lord. Then your lordship may kindly see, my lord, page 26, page paragraph 265, my lord. The court, my lord, is court, my lord, between, my lord, the state and the board and the SSC. It's a strange stranglehold on the court. Your lordship may kindly see, my lord, page 265. This is, my lord, a state is supposed to be a model employer.
Yes.
Paragraph 265, my lord, beginning inferences from the role of Article 12 authorities. Inferences, my lord, if I may read, my lord.
Yes.
In fact, a paragraph before that, the stand taken by the Chief Secretary. These are very harsh words, my lord, the court was compelled to use, my lord. Paragraph 264, my lord. The obdurate attitude of the Chief Secretary has to yield to his obligation to uphold the rule of law. They were all along, my lord, there are a number of words, my lord, the learned judges use, my lord, as to how they are trying to play ducks and drakes. I can, my lord, highlight, my lord, in a one-page, my lord, note as to how, my lord, these three authorities, my lord, have tried to mislead the court in three different directions. Your lordship may kindly see the para I, my lord, wished your lordship to read, my lord, para 265. The government therefore has accepted that there were widespread illegalities in the selection process and that the number of persons who received appointments illegally could not be determined with exactitude. So 242, my lord, has to be read, my lord, with 265. And then, my lord, they go one step further. Now, my lord, you detect the illegalities and you perpetuate them. The next line is very important. They had resolved to create supernumerary posts to accommodate the illegal appointees.
That's one thing we'd like to know. Paragraph 265. As far as the state government and the SSC is concerned, you accept that statement of fact?
SCC at least.
1 minute, please. SSC, because this is on the basis of what has been stated. Be careful that you don't make a wrong statement. Just be careful you don't make a wrong statement, because if it was so stated before the High Court, it's matter of, so must be a matter of record.
Lord, it is there at page 30 in the submission, my lord, para 30, my lord. The submission made by SSC in the High Court.
They just read out that. But just we like to answer after they've completed. We'd like you to answer that.
Para 30.
Para 30 of the written submission.
30 minutes of the MP, lord.
Judgment.
Yeah, while dealing with their written submissions.
So this is the, my lord, admission, my lord. They have admitted before the High Court. Page 106, my lord, para 30, contentions of SSC, my lord. Excellent. Para 30 minutes.
Yes.
Dr. Sutanu Patra, appearing for the School Service Commission, has referred to the 4 affidavits filed in pursuant to the order of this court. Lord, the affidavits, my lord, your lordship can make a note, my lord. They are at page 545 to 553, 545 to 553, 554 to 604,
554
to 604, 605 to 701, and my lord, 701 to 756.
Yes.
But he has drawn the attention of the court to the steps and measures that SSC took subsequent to the discovery of illegalities in the selection process. He has contended that SSC took such steps on the basis of the data supplied by CBI. He has pointed out that SSC had no material to disbelieve the data supplied by CBI. Not CBI also, my lord, is in an ever evolving process. They are still in the process. Moreover, SSC has acted pursuant to the orders of the court. Lord, I'm not.
No, but this is something different from what is
read out at 242.
what you read out at 242.
Yes, my lord, what at 242, what I read out, my lord, is, my lord, the conflict between the board, my lord, and
No.
They said that they did not discount the fact that the possibilities of further illegalities exist.
yes,
Did they say that in any of those 4 affidavits?
Anyway, please, somebody else will point it out. If they...
Your lordship may kindly, my lord, I'll just read, my lord, para, my lord, 271, my lord, and my lord.
4 affidavits to disclose that they have been varying from time to time. It's referred to in the submission.
My lord, when the illegalities were seen, my lord, the numbers are given 271 and then, my lord, page 229. Justification that has been sought proffered by the board is that all appointment letters are on the basis of the recommendation of SSC. But SSC has contradicted such justification of the board.
Which page are you? Which paragraph?
Not para 271, my lord, on the next page, para 229.
Oh, yes.
Justification that has been sought proffered by the board is that all appointment letters are on the basis of recommendation of SSC. But SSC has contradicted such justification on the board by claiming that no such recommendation letters are issued. So between the SSC and the board, my lord, there is open contradiction.
In any case, you are beyond recommendation.
And my lord,
We have taken that into consideration in the number we have given of the intent.
Para 271 documents the number of excessive appointments in each category.
There is a reason for
After this, you got together and patched it up.
yes. Not zero, none of the No, your lordship may just imagine, my lord. Your lordship may just imagine, my lord, an OMR sheet, my lord, where nothing is written. Just imagine, my lord. And my lord, it is checked, it is recommended by the SSC, my lord, appointed by the board. Just, my lord, and my lord, your lordship may just see, my lord, what these people are going to impart education to children. Where will, my lord, this country go? No, according to me, my lord, what?
Suppose somebody is recommended and he doesn't take the post, then a second recommendation has to.
We understand that. You're not,
That is always.
Derek, you don't have to argue that is, we understand that part. You don't have to argue that. But look, you also realize there is wrongdoing. Question only is wrongdoing is of that level that we can't now separate merit from illegally appointed. So that's all.
At 5 different.
That's you are also in this. You are also helpless. In a way, you are helpless.
No, Mr. Gupta was
And the board.
Mr. Gupta was kind enough to say, my lord, at the first instance, Mr. Gupta was kind enough to say, my lord, that he can't improve post facto. He can't improve. Then the
Merit continue, please. It's already good. It's more. We have already crossed about 4:45. Please let it continue.
Duplication is marginal, that's about it. I won't say anything.
Duplication of arguments.
But para 273, I'll just complete now. Your lordship will not have been patient enough to
Okay.
everybody, my lord. But para 273, my lord, after my lord, the infighting between the SSC and the board, my lord, as to my lord, the kettle calling the pot black or vice versa, my lord. Lord, SSC had at no stages of hearing, claimed that it was able to check all the records and be definite as to the number of illegalities in recommendations made, but had limited itself only to those figures. So they could never check also, my lord. And my lord, that could reflect, my lord, in one of the affidavits, my lord. I had referred to, my lord, 3-4 affidavits. It is at page 650, my lord,
Miscellaneous volume 5B.
of miscellaneous volume 5B, my lord.
This is a pink pen.
Done?
Paragraph such as paragraph 6.
Paras at page 650. This is the SSC's affidavit, my lord. Hopefully in black and white. May I read, my lord?
Yes.
Para 6, my lord. However, I say that there may be more candidates who were wrongly recommended for appointment by the commission, for which I most humbly pray for some more time to further verify the records of the commission and to produce the list of such
The date
candidates.
of this affidavit.
No, I'll just give it to them.
This is affidavit
This is the third affidavit, my lord. Third?
September 22.
Dated
September 22.
22nd September.
22nd, my lord.
September 2022.
22.
28th September.
This is the third affidavit.
Number identified so far.
Number identified so far.
It's 315.
So, my lord, there is no definite number, my lord, as to the number of illegalities committed. They are all hunting in the dark. No, your chart is worthless, my lord.
Sir, page 315 identified so far. Page 315.
Okay, yes.
My lord, there's another chart, my lord, my learned friend here, my lord, prompts me to, my lord, request your lordship to kindly see, my lord, at page 3154, my lord, of the same volume 5B, my lord. Ours is volume 5B, my lord.
3154.
54, my lord.
Yes.
Simplified so far because before the division basis.
My lord, where class 9, 10 is mentioned, my lord, it says, my lord, number identified so far. Well, Mr. Bhattacharya, my lord, has placed that. Now, my lord, if your lordship may kindly see, my lord, the stand, my lord, of the learned advocate also before the High Court, my lord. I should not be reading this, but in fact, if your lordship may kindly see, my lord, para 268, my lord. Your lordship may read it.
Yes.
Lord, para 268, my lord, this course of action has been adopted by the state. Your lordship have that, my lord?
Yes.
In order to prevent discovery of further manipulations, illegalities in the selection process if possible. And now very important, my lord. The SSC, the board and the state government have consistently stonewalled any queries with regard to the selection process and have not come clean with regard to the manipulations, illegalities involved. The conduct of the three authorities during the course of hearing can be classified as anything other than being cooperative. Lord, there are other words not used, Lord, for the advocates appearing, Lord. I don't, Lord, want to wish to highlight it, Lord, but just suffice it to say, Lord, that there is a three-pronged attack, Lord, on candidates, Lord, who had good marks, Lord, who could have, Lord, been good teachers. But, Lord, because of this monetary consideration, Lord, today, Lord, I'm given to understand, Lord, that the minister is still in jail about 2 years' time, Lord. 50 crores found, Lord. I don't want to, Lord, put the criminality into it, Lord. But, Lord, the level to this, the level, Lord, to which these three authorities, Lord, have fallen, Lord, to ensure that the education system, Lord, somehow is, Lord, affected, but by pockets of food. And this is, Lord, the basic feature, Lord, in this large, as Mr. Bhattacharya said, Lord, institutional criminal conspiracy, Lord. And, Lord, I would say, Lord, one thing, Lord, if your lordships are, Lord, with us, Lord, then there are, Lord, there is a direction passed, Lord, for return of some monies, Lord, for those people who somehow taught within inverted commas. My, Lord, prayer and request to your lordship would be, Lord, to make this as an example, Lord, and, Lord, fix the three authorities with such cost, Lord, so that this never happens again, Lord. It should be, Lord, I think, Lord, at least 500 crores for each of them. It would be, Lord, if you make a calculation, Lord, I was there, Lord, about 7 to 8, 10 lakh rupees each candidate has paid. Is, Lord, what is in the corridors and the grapevine, Lord, has got, Lord, enough effect.
So, yes, next.
What Mr. Rahim has said, para 329 also virtue will not. I mean 103, which is the culmination of what Mr. Rahim has argued. 329 is the conclusion. And that's where they say it cannot be segregated. So that's why cancellation of the entire selection.
Lordships, I'm appearing for the people who are saying that it can be segregated, and I'll just explain to your lordship.
So, appearing for?
The people who are saying that it can be segregated.
No, you should have come on this side.
This is what we say. Should
I'm
come
on
that
this
side.
side because I'm not selected, your lordships. I would.
No, we were very clear. We were very clear, you should have come on that side.
The reason is this, that I have.
So, just wait for your turn, let others conclude.
Yeah, just read this para 329. Yeah, that's what
We have already marked that paragraph.
Great. This is the entire conclusion that why this selection, this cannot be segregated.
Anybody else?
Therefore, it should be cancelled totally.
But Mr. Ghoshal was there on the other side, not that time. Lord, so I would respectfully say, request him to be on that side again.
Anyone else supporting Mr. Rahim and Mr. Bhattacharya?
You can't be on that side and then here.
Anyone else supporting both of you?
I would
Only two of you then.
may I only send to state since
If Mr. Vikram or Mr. Firdaus wants to add a line, Lord, they are youngsters, Lord. I told them that this court would hear everybody, Lord.
Just want to place one thing, the School Service Commission and the state must come up with a definite stand. And before the High Court, they have not come with a definite stand how as to the number of illegalities. Even then, courts of hearing, my lord, one after another affidavits came up, but the stand of the state as to the definite number of illegalities, neither the state nor the School Service Commission could submit before the court. And what I want to respectfully submit, your lordship, is that whether illegalities would exist in future or not after the identified numbers. In that event also, my lord, the chairman of the School Service Commission is physically present. He also cannot say throughout the entire selection process whether further number would come out or not. He is personally present before this court. With this, my lord, I end my submissions. Thank you.
My lord, I am supporting Mr. Rahim and Mr. Bhattacharya, my lord, only on the 4 affidavits that have been filed before the division bench, my lord. The first affidavit, there was a full bench decision of the School Service Commission. After the first affidavit, the second affidavit came saying that the first affidavit is not exhaustive. They gave a list that these are the number of illegalities, where, my lord, certain illegalities were not given. Third affidavit, they say, my lord, it has been already placed that identified so far. And the fourth affidavit, my lord, which has also been placed before your lordship, states that in clarification of the third affidavit, we found that these are. So till date, the division bench gave them chance to file 4 affidavits. SSC is not clear what is the figure, exact figure of illegalities, because, my lord, kindly one thing, since there are 100 vacancies and 150 candidates have been appointed, my lord. So who are those extra 50%? SSC cannot identify. My lord, admittedly, 100 recommendations, 200 appointments, and they are saying that we did not issue. And this has come from Justice Bach Committee reports also. Those persons are not identified. And interestingly, my lord, if your lordship sees the written submission of SSC filed before your lordships, they have not said, they have not given the figure who have been appointed after more than vacancies and more than recommendations, only because these cannot be segregated and these cannot be identified. And other, my lord, I adopt the submissions of Mr. Bhattacharya.
In addition of submission made by my learned senior friend, my lord, but I just give the impression which my learned friend time and again says that we gave the figure before this court. My lord, kindly take the final compilation volume 6, which is in written submission given by the School Service Commission, page 16 and page 17. The figure which is given by the School Service Commission before this, sorry. The figure which is given by the School Service Commission in this tabular chart, and if we add these 3, that is rank jump, out of panel and OMR sheet issue, the number came out 5,485. And the my lord will remember the last occasion on behalf of the board, one tabular chart handed over, which is this, my lord. And if we add this number, so that come out 5,189. Even the document which is placed before this court, there is also mismatch between these 2 Article 12 authority. Apart from that, my lord, the expiry of the panel, which is evident from this tabular chart, that is out of panel and expiry of the panel. Kindly turn, my lord, volume 5B, page number 2966. A tabular chart which is given, where, my lord, it is evident the publication of final vacancy dated 11 September 2017. And according to the rule 15 of 2016 rule 15 is page number 959. May I read the rule 15?
Yes.
Rule 15 says validity of panel and waiting list. May I read?
Yes.
Each panel and waiting list shall remain valid for 1 year from the date of publication of the panel and waiting list, or the date of advertisement for the next selection test, whichever is earlier, provided that the names of the candidates shall not be recommended against any post other than the post applied for, or against any vacancy which has not been notified in terms of clause B of sub-rule 3 of rule 8. So it is evident from this rule, validity of panel is 1 year. Kindly see, turn page number 2966. The second 2966 of volume 5, 5B, 2966. Very interesting, my lord. Date of publication of result is 11 September 2017. So panel validity lost on 11 September 2018. Kindly see, my lord, date of counseling. First date of counseling is 16 July 2018 to 22nd July 2018. Second round of counseling 29th August 2018 within the validity period of the panel. The next counseling, third counseling, after expiry of the panel. Fourth counseling, after expiry of the panel. Fifth counseling, after expiry of the panel. Sixth counseling, after expiry of the panel. So, every counseling hold after second round of counseling, it is regarding 11, 12. My lord, kindly see the 9, 10, page number 309, 3009, a tabular chart which is evident that date of publication of final panel 12 March 2018. So, the panel validity expired on 12 March 2019. Kindly see the date of first counseling, 12 March 2018. Then second counseling, 5th February 2019. Then third counseling, after expiry of the panel. Fourth counseling, after expiry of the panel. That's to up to 8th counseling. So, in their affidavit, they say only 8th counseling is after expiry of the panel. But rule says from third counseling onwards, every counseling after expiry of the panel. That's my humble submission, my lord. So, my lord, whole selection process, the submission, which is done before this court as well as the written submission.
Counseling, because personality is personality.
My lord, may I, my lord, place the rule. Rule is that, my lord. First, if this selection process is 100 marks selection process. Out of the 100 marks, 55 marks for written examination, 35 marks for academic excellence and professional qualification, and 10 marks for the interview. After 55 marks evaluation, they ought to publish a list that called interview list. They publish the interview list in accordance with law. Rules is that very specific. My learned senior friend plays the rule. Rule is that they ought to publish the marks with breakage of marks. In the year 2018, they not publish the marks. They gave the one-to-one communication, which my learned senior friend says.
No problem, they publish the list without the marks.
Yes, my lord. Without a mark, and that too, my lord, that too not in interview list, because in the rules there are 3 type of list. May I place this rule if my lord's one? If my lord not one, I place it because the whole rule is, my lord.
12-6. 12-6.
12-6. 12-6. May I place the rule, my lord?
12-6
Rule,
you've already seen.
rule 2 is the definition section. There are 4 type of list. 2F says about interview list. 2F. May I read the page number 955. 2F says about merit list. Interview list. Interview list means interview list means a list of candidates to be called for personality test, category-wise on the basis of merit, marks of written examination, academic and professional qualification, in the ratio of 1:1.4 of final vacancies. Suppose there is 100 vacancies, so they ought to publish 140 candidates' marks with all details as an interview list, but they not published it. It is pre-interview, and after interview there is a list that called merit list. That merit list definition is also in the rule. Kindly take the definition of merit list 2G. 2G says merit list means a list of candidates prepared category-wise on the basis of marks obtained by a candidate in written test, in academic and professional qualification, and in the personality test. But in the year 2018, they not published this merit list in accordance with rules. We came before this court in the year 2021, when we came to know about that candidate, some candidate who are the less meritorious candidate, whose number is whose merit position is less, because number is at that point of time number was not published. Number published in the year 2022 when the court give that direction. In the initial year, in the year 2018, they not publish the even interview list. They only give one-to-one communication to a particular candidate.
Interview list is probably published. We just get the clarification from them. They're saying interview list was published. It was not 1:1, and then they published the final list, pursuant to which probably when appointment letters were issued, some people got into it, and they then filed that why is marks list not been published. So then the mark list got published. When the mark list got published, then the whole thing blew up.
With request of respect, that is not the position. Position is that there are 4 type of list. One is interview list, another one is merit list, another one is panel, and another one is waiting list. Suppose pre-interview, they ought to publish a list that's called interview list.
We have understood that.
Post-interview,
We have understood that.
post-interview, merit list. And from that merit list, two type of list will be there. One is panel, another one is waiting list. So they ought to publish 4 lists. But instead of that, they publish 3 lists. I'm extremely grateful for patience hearing, my lord.
Well, next Monday, my lord, there's a holiday, my lord, in Vasant Panchami. So we will all be having.
No, we will not be, probably.
Can it be on 4th, my lord? Can it be on 4th, my lord?
It's not a holiday. It's not a holiday.
It's in Calcutta.
It's in Calcutta, all of us, because I have to take certain submissions, but we have puja at our chamber because Saraswati Ma, like, can it be on 4th, my lord? Only, can it be on 4th? 1 day's accommodation, my lord, we are seeking, my lord.
Then we'll go to next week. Beyond that. No, Friday we're not seeing it. 10th. And 10th we're going to conclude whatever way we want to.
Keep it on Monday.
Keep it.
Councils who are here, we can finish your lordships.
Friday may not be possible.
Your lordships Monday, your lordships is.
Lordship, can it be on 4th? My lord? That's
Problem.
difficult.
Just see, we can't help it. We'll keep it on 10th.
Councils who
Then-
argue.
You
I
can-
can argue.
10th to okay. Yes, please.
My lord, sir, last time I had mentioned the transposition application and my learned friend had said he wants to examine it. It's fairly uncontroversial. I was an appellant in the High Court. This man just didn't have the resources to file a petition.
Whatever.
He's a legal aid candidate. Can he just be transposed? Well, as I hand up the IA number,
Very bad practice way from him.
he was.
10, 2 p.m.
যদি ওই নাম্বারটা ওই ব্যক্তি ডকেট করলে তাহলে রইল, তো আবার ওই 3 মাসের মধ্যে না যদি ডকেট করে তারপরের 3 মাসের মধ্যে আবার ওই নাম্বারটা মার্কেটে ছাড়বে। মানে এবার বুঝেছো, মিনিমাম এদিক ওদিক করতে গিয়ে 1 বছর পর আবার ওই নাম্বারটা আবার মার্কেটে ছাড়বে।
ফেসবুক খুলছিলাম তো দেখলাম 2-3টা ফেসবুক আইডি আছে অলরেডি, এই জন্য জিজ্ঞাসা করলাম।
বুঝেছো? কিন্তু ওগুলো
আরে ওরকম আরে আমি সে সিম কবি 2014 সালে, তার আগে কে লিছিল, তার কি 12-7 কোটি কাকে নাম্বার দিয়েছে একটু কোটি অমুক লোক বলছে 12-7 কোটি থেকে উকিল হয়েছে। আরে আমি করে আর আমি অন্য লোকটা কবার করি সে মাঝে ফোন করে তার তার কি কেস 12-7 কোটি।
এর যে প্রথম নাম্বার আমার কাছে সেভ আছে, তাকে তার ফোন করলে কাজ একটা লাগিয়ে যায়।
আরে সে এ সিমটাও তো 2014 সালে, এই 10 বছর আগে, তার আগে কার থাকে।
তুইও কথা বল, আমার যে এয়ারটেল সিমটা সুখেন্দু তখন সুখেন্দু প্রাণী তার নামে নতুন নেটওয়ার্ক হয়েছে। তার আগে কার নামে ছিল, খালি তার ঠাকুরদা এটা সেটা সাইড নু তার কাকে তার ফোন করে যায়, শুধু ওই নাম্বারটা কল হয়েছে রং নাম।
ওই ওর তো তোরা ওটিপি বন্ধ করে দিবি সব, যা যা ছিল
এই যে ব্যাপার, আর কিছু না। আরে আমাদের দোকান আমার 14 সালে দোকান স্টার্ট, 14 সালে চেয়ে কিন্তু কত সালে দোকান করছে আমার আগে, ধরো 2010 সালে সে করছে, তুই তখন পুটকেরা হয়তো সেটি সে এধারে যে হাজরার এধারে যে এখন মশারি কাটে না লোকটা বুড়োটা, তার উপর তার বেটা আছে জামা প্যান্ট কাটাইতে জানি তো জানি তো সে যখন দোকান করে তখন তারও রিটপ এটা আমার পাশে যে এয়ারটেলটা আছে তার রিটপ, সে নতুন রিটপ নিয়ে তার চলার পর সে আমাকে দিয়েছে, তার দোকান বলে আমাকে দিয়েছে, ঠিক আছে। সে যে আমাকে দিয়েছে মানে দিবার কারণটা আবার কি, সে ভোডাফোনের ডিস্ট্রিবিউটারের একটা কোড নিয়ে নিয়েছে, নেওয়ার জন্য সে ভোডাফোনের কাজ করে এয়ারটেলে কাজ করতে বলে ও আমার যে আমার রিটপটা লোককে দিয়ে দিচ্ছে, তার ইউটিউবটা আমি নিয়েছি, সেই ইউটিউবটা আবার আমার নামে করে নিয়েছি, এরকম হয়েছে। সে তাহলে 2010 সাল, আশা করি তার আগের সিম হয়তো, সেদিনকার সিম যদি ঠাকুরদার লোক বলে যে অমুক লোকের এটা নাম্বার ছিল এরকম ব্যাপার, তাহলে কি করবি তো তাই 2 দিন আগে।
আরে অনেকে আছে বলে খাতায় লেখা রাখে না নাম, এরকম তাটেট লাগিয়ে দাও। আরে কি বন্ধু লোক তারা জয়েন হলো লেখাটা দিয়ে রাখছে
কত 21
ও লেখাটা আছে না, আর অডিওটা চলছে, অডিও হটে তোমার বন্ধ করে দাও তোমার। আমাদের কথা কোথায় শব্দ আলাদা শব্দ ইউটিউবে চলছে ভিতরে, তার রুম ঘর পাইছে নাকি
নাম্বার
86 20 94 আর কি করো না পাবো
86 49 88
3 ঘন্টা
86 49 88 27 83 কি করবো
কোনখানে পড়তেছে আছে
কিন্তু ডাউনলোড স্পিড কম আছে, 36-37 ডাউনলোড স্পিড ছিল,
সিস্টেমটা বানালো ছিল
28 ডাউনলোড স্পিড, ভালো চলছে।
কালকে মনে আছে তো দেখতে বলছে
তুমি জানো মাস্টার আছে
নাম্বার 81 45 24 13 81 45 24 13 99 মান দিবি রিচার্জ নাই মানে তো হবে না, 17 জানুয়ারি শেষ হয়েছে। প্যাকেজ না থাকলে বুস্টার প্যাকেজ হয় না তো
শুধু বুস্টার সে তো আমি
কবি
করে গেলাম
প্যাকেজ ছিল তখন ধরো তোর যে এই যে 17 তারিখ শেষ হচ্ছে না 17 তারিখের আগে মারছো
20-21 দেখে বন্ধ করে দেবো
তাই কি মারবো কো দিদা যাবি আমার সঙ্গে তো আমি যাবো তো আবার আচ্ছা আর ওদবা কার বসকে যাবো আর ওদবা কার বসকে যাবো তো তুই আর আমি হ্যাঁ
আমি তুই নতুন লোক লেগে গেছো তুই এবার কচুবুড়ি না বর্ষা লেগে খেতে গেছিল ঠিক তাহলে যে আকাশের মাঠ এসে গাড়ি হয়েছে সেখানে তুই এক লাইন ফাঁকে ও ভিড়ে যাবে
And this was the affidavit filed before the Supreme Court by an affidavit on 16th of March 2023.
দেখিয়া তো অত আর কমই যাবে
এবার কমে যাবে
বন্ধ করে দিই
Now that I know is well settled, I really like to bring one judgment to your lordship notice. By the Supreme Court has said if there's any out of doubt,
78 ঘন্টায় 78.7 মানে 80 বাড়বে তো সত্যি তো বাড়েনি আর আগেরটা কত হয়েছে এখানে আগেরটা তো কম ছিল আগেরটাও 14 ঘন্টা হয়েছে মানে 80 আগের 1 ঘন্টাটা আলাদা শেষেরটাই তো বেশি আর প্রথমে যেটা কেটে দিয়েছিল সেটা হয়েছে 14 ঘন্টা হয়েছে এটা আগেরটা যেটা আগে কাটিয়েছিল নতুন লাইফটাই যে 78.7 ঘন্টা বেশি হয়েছে মানে তো আবার শেখা টেখা আছে টোটালি ভিউজ আজকে টোটালি ভিউজটাই দিয়ে হয়েছে আইছি কত আজকে এই ভিউ হয়েছে 5000 হয়েছে
5088
আগেরটা বাদ দে আগের দিন আছে টোটাল 48 ঘন্টা
2015
দিয়ে দিলে আমি ফাঁকা হব দিয়ে দিলে আমি ফাঁকা হব
তোর লাগলে এবার যাবি ওধার
ও উলিয়াই তো দোকানদারকে দিবা না হলে কি দোকানদারকে দেয়নি হ্যাঁ 50 নেই 50 কাকুকে তখন দিয়ে দিছি দুটা
আচ্ছা বন্ধ করে দিল 10 হয়েছে বন্ধ করে দিল ফালতু ফালতু করে হবে
কত 2 ঘন্টা 3 মিনিট 46 সেকেন্ড চলছে
কি দেখো
ওটা এই যে সুপ্রিম কোর্টে যে এইটা ছিল
এটা আছে ইউটিউবে লাইভ আই সুপ্রিম শুনানি দিল না
কিসের
চাকরি বাতিল
হ্যাঁ কি হয়েছিল শুনে তো
আজ হচ্ছে নি আবার ডেট দিছে পরে আবার
ও শালা মাস্টার রিটায়ার হয়ে যাবে তার মধ্যে আবার কিছু মরে যাবে কয় ডেট কিছু বউ পেনশন পাবে হয়তো বড় জোর তার বউ পেনশনটা বন্ধ করতে পারে আচ্ছা রিটায়ার হয়ে যাবে কিছু মরে যাবে তার রায়ও জীবনে হবে না তুমি লিখে রেখে দেওয়া ছিল
আরে কি লোক তো এখন সারা দিন কি লাইভ হবে
আপনার লোক ঢুকিয়েছে
10 তাহলে লোক দেখতেই আছে ये চলো 7 রাউন্ড চালিয়ে ছড়া গুলো জুড়িয়ে বড় গাড়বে বন্ধ করে
রাষ্ট্রপতি কি হয়েছে আবার কবি রায় দিয়ে দিচ্ছে
ডেট দিছে না এ তার তো শোনা হয় না ডেট দিয়ে আমি দেখতে পাই ওরা ভেবে 7টাই বাড়িবে তার 10-15 হইতে ঢুকে রে বারাডে হ্যাঁ মানে বন্ধ করে দেবো
মেলা গেছো মেলা গেছো হ্যাঁ মেলা গেছিল মেলা কি লিচু ওই দেখ মেলা কি লিচু মেলায় কি লিচু বাবা
ये 10 মিনিট ফোন না খেটে খেতে পাইছে মনে হয় ये 10 মিনিট ফোন দেখে দেখে ঘুমাতে চালিয়ে দেব না এনে কোনো না আমার চ্যানেল গেলে হয়তো আবার লাইভ করতে কি দেখ হয়তো বানানো পারে তো এই বাড়াই কি বন্ধ করে দিতে 13 হয়ে গেল খাই যা বলো সারা বছর তো টিউশন পড়াই 10 মিনিট বুঝলি যে সব
তুই সব গোছা ওকে আমার পাশে রাখি যা